Well, the Act was seen as a visionary piece of legislation. It empowered people who had learning disabilities, who suffered from dementia, who had had a brain injury, or who had other temporary disabilities. It empowered them to take decisions, important decisions, in their own lives whenever that was possible, without having to rely upon decisions being taken on their behalf by others. It was described by witnesses as positive, progressive, a wonderful piece of legislation, and therefore that was the measure of it. And it was important for us to see whether the aims of the legislation were in fact being achieved in practice. It's a good piece of legislation, it's a good act, and it's important that it is implemented. Well, we heard evidence which consisted of about 2,000 pages and came from more than 200 written submissions and more than 50 witnesses who gave evidence. And the clear message from that evidence was that the Act is not being implemented. The implementation generally is poor. And in the health and social care settings, either there was lack of knowledge about the Act, or where there was knowledge, it wasn't implemented. In short, implementation was, the evidence of implementation was poor. That was compounded by the attitude of the government, because at the start of the inquiry, the impression created by officials in the respective departments was that implementation had been effective and it was more or less complete. As time went on, and evidence tended to show otherwise, the government established the Mental Capacity Steering Committee, which is intended to implement the Act. And also the ministers at the end, when they gave evidence, they described implementation as work in progress and indicated that they were looking to us, to the committee, for assistance. The first key recommendation of the committee is the creation of an independent body which will have responsibility for the oversight, monitoring and driving forward the implementation of the Act. This body will not be a regulatory body. It will have responsibility for all sorts of issues which are identified in other recommendations, such as education, culture change, and so on. And the need for such a body is emphasised by the fact that hitherto implementation has been undertaken by different and disparate bodies with no coordination. This body will be the answer to that. The creation of this body will not, of course, remove from the minister the responsibility for the implementation of the Act, because there will continue to be ultimate ministerial responsibility. Our second key recommendation concerned the deprivation of liberty safeguards, which were introduced as an amendment to the Act in 2007 and in response to the Bournewood case. The evidence indicated that these were not understood. Their aim was to protect individuals in certain situations. For instance, if you had someone suffering from dementia living in a care home, it may be appropriate to prevent that person from leaving the care home unaccompanied in the interests of his or her safety. And that's the sort of issue that, where deprivation of liberty safeguards might apply. But the evidence indicated that they weren't understood in the social and healthcare sector. Where they were applied, where they were understood, they were not applied. And the evidence suggested that lots of people, indeed tens of thousands of people, might be being deprived of their liberty without the implementation of the safeguards falling upon the Bournewood case. Indeed, it was suggested, and we accepted, that the present situation might be equally problematic as far as the rights of an individual are concerned. And so, but it wasn't simply the implementation of these safeguards that was a problem. There was a great deal of evidence from all sources, including judges, who seemed to think that the legislation was badly framed. So that the only answer to that was to tear up the provisions altogether and start again. And hopefully that procedure would involve the same pre-legislative scrutiny as the main provisions of the Act enjoyed, and appropriate legislation would be put in place for the protection of vulnerable individuals. Well, the government will respond to our report in 2 months. After that, there will be a debate in the House of Lords. And we recommend that the House revisit this issue in 12 months' time to see to what extent the government has implemented our key recommendations and the other aspects of our report.